Why is it that when a room full of people see an event, we so often get a room full of different descriptions of what happened? We'll talk about eyewitness testimony right now on the Law Works.
From West Virginia Public Broadcasting.
Closed captioning for the Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
Can you believe your own eyes? Well, it depends. My guest is West Virginia University law professor Valina Beatty. Valina, welcome back. You've been here before.
I have. I'm happy to be back. Thank you.
How did you get interested in the subject area of eyewitness testimony, eyewitness identification?
Well, I'm the director of the West Virginia Innocence Project, and nationally, over 300 people have been exonerated through DNA evidence. Yet, in 75% of those cases, there was a mistaken eyewitness identification. So the eyewitness chose the wrong person, and that led to the wrong person going to prison.
So there was an eyewitness who said, I saw him or her do whatever it was. That person sitting in the courtroom is the person I saw, but they were wrong, as the rest of the evidence later demonstrated.
Correct, and DNA is particularly forceful in being able to show this was inaccurate and incorrect.
Well, the problem, though, with having conflicting evidence like that, DNA says not him or her, eyewitness witness says, yes, that's the person I saw, is that if you throw out the DNA evidence, that doesn't mean the person gets to go free, because there's still evidence that it was that person.
And that's what brings us into all of this research and interest around eyewitness identification and trying to make it more reliable. If we're going to rely so heavily on eyewitness identifications, we need to make sure that they're as accurate as possible. And a number of studies have been shown to demonstrate that our memory is more malleable and can be influenced more than we tend to think.
Does that mean that I don't know what I saw?
No, but it does mean that you may be subjected to certain influences. Perhaps if, for example, you're shown a lineup of photographs and you see a photo array of all the photos together on one sheet, and you think the perpetrator has to be there on the sheet. So you start comparing between the photos, has to be one of these people, and you choose the person who most looks like the perpetrator, which may not be the perpetrator.
Now, lineups, if you watch television, you become convinced that a lineup is a parade of 5 or 6 people, more or less, on a stage with numbers about height and things like that behind them, with a two-way mirror where the victim or the witness looks through the glass and picks out the criminal. That doesn't really happen very much. I don't even know if it happens at all anymore. What typically happens is what is called a photo array, where photographs are, well, to paraphrase a line from the most recent presidential election, there's a binder full of suspects or criminals, and the witness is asked to identify from some or all of these pictures the person that they saw do whatever it was that was done. There are problems with that.
Correct. And there's actually simple reforms that can be put into place to make these identifications more reliable.
Well, how is it typically done now? Or what are you concerned about the way it's done now?
Well, a number of states do a lineup of all the photos on the same page, and the person who administrates the lineup, who gives the photos, is an officer who knows who the suspect is. Now, again, nationally, because of more scientific information that we know now, nationally that's changing, and it's changing towards showing the photos one at a time. That way the witness is comparing each individual photo to her memory. And equally important to that is that the officer who's giving the lineup doesn't know who the suspect is. To have those two combined, that it's sequential as well as a blind administration. And if I may, there's an easy way that a number of offices have adopted to make it a blind administration. Because you can imagine for small offices, they may not have an officer who doesn't know about the case. And the solution is the folder shuffle method. Take manila folders, you put each individual lineup photo in a separate folder, shuffle the folders, give them to the witness. And that way the officer doesn't know which photo the witness is looking at.
So the witness would have a photo that only the witness would see, and they would say yes, no, or I don't know.
Exactly, exactly.
I have seen police officers ask witnesses to identify people. And what I have seen is not a typical photo array lineup. Usually these are in drug cases where the police is trying to find out from whom the witness bought drugs or who they saw dealing drugs. And all of the photos are obviously photos of criminal suspects. They're either the kind of photo that you take when they're booking you with the numbers on the back showing your height, or they look like they've been beaten up, or they're half asleep, like they're on drugs. So it's pretty obvious that in this binder full of suspects, everybody is guilty of something, or at least strongly suspected of being guilty of something. Does that kind of information affect what the witness does, or what the witness says?
That can. That's not absolutely. But what is important in that kind of scenario, or equally important I should say, is an instruction to the witness that the perpetrator may not be here. Despite seeing a binder full of people who have already been convicted of some offense, the perpetrator may not necessarily be here. And even if you don't choose someone, we're still going to continue to look for the perpetrator. And West Virginia actually has legislation in place that was passed in 2007 that requires and mandates that law enforcement give that kind of instruction to mediate exactly those concerns that you bring up.
To say that the suspect may not be here, or the perpetrator may not be here. We're talking about eyewitness testimony. My guest is West Virginia University law professor Valina Beatty. I'm Dan Ringer, and this is The Law Works. I don't know of any police agency that has photographs of upstanding citizens that they put into photo arrays.
Oh.
Some might, but I don't know of them, and I don't know where they would get these pictures from. Nobody's ever stopped me on the street and said, can we take your picture to put in our photo array to see if you're identified as a criminal? I don't think I'd want my picture used for that.
True, but that doesn't mean that the photos are necessarily suggestive. Doesn't mean that the photos necessarily are the person in prison garb, for example, or something that would specifically identify the person as a criminal.
Well, I can see that we take a picture of you. In fact, we're taking a lot of pictures of you right now because we're recording this program. But nobody ever says, can we have a frame capture, it's what it's called, a still photo of Valina Beatty, because we want to use it in lineups. They could go online. There are photos of you, there are photos of me on the internet. I don't know that they lift those photos. Shouldn't a fair lineup have pictures of ordinary people in ordinary situations instead of the suggestive photos that there's something wrong legally with this person?
Well, realistically, law enforcement does have limits on their capacity to be able to gather photos for a photo lineup. And some of these photos may be from people who have much smaller crimes, not necessarily, murder or assault. So we have to recognize that law enforcement is trying to do the best that they can do with compiling these lineups. But I think you bring up a good point that the accuracy of representation, the accuracy of identification matters to all of us. It matters to the person who's wrongfully chosen, even if there's someone who had been convicted of a crime previously. And to further explain a bit about the safety impact of this, with the West Virginia Innocence Project, the concern is both there's someone who's wrongfully convicted, as well as the actual perpetrator is still there on the streets. So having an accurate identification helps to make sure that we don't have the perpetrator out in the community. And we know from some statistics and studies done from real perpetrators that often they go on and commit other crimes in that same community. So this reinforces the importance of an accurate identification.
Yeah, there's kind of a folk tale about people who are serial offenders who commit the same type of crime over and over again, is that for each time we have caught you doing it, you've done it 10 other times. So if we can take you off the street, assuming you are the guilty person, get you off the street, then we have stopped more crimes than we have identified. And that's probably a worthy goal. Well, what kind of factors can affect my ability to accurately see and report on what I have observed?
Well, there are environmental factors. There are factors that are really out of your control. So the weather, or whether it's daytime or nighttime, what the lighting is like, the distance from which you see someone, your own eyesight, if you're inebriated. There's a number of environmental factors that can influence what you see and how well you remember it. But there's also what are criminal justice related factors. And that's where the lineup comes in. That's where there are things that we can control. We can control how a lineup is done. We can control whether a witness is influenced to misremember, actually. And those are things we can control in our criminal justice system.
What kind of things happen that are improper?
Well, it's not always necessarily something that's improper, but often when an officer is giving a lineup to a witness to choose who the potential perpetrator is, the witness will read into what the officer does. I mean, the officer could consciously or subconsciously be influencing the witness's choice. And this is why it's important also to have an instruction, a statement to the witness that the officer doesn't know who the suspect is either. Because if the witness thinks the officer knows who it is, she's going to be watching, oh, how is he reacting to me choosing this photo? While if the officer just doesn't know, and if the witness knows the officer doesn't know, you take out that potential taint.
Some of the photo identifications I've seen, the officer will say, do you recognize anybody on this page? Because they in a binder with a number of pictures on one page. And the witness will say, yeah, I recognize him, or I don't recognize anybody. And then the officer will say, well, what about this one up here? And we'll point to one and say, do you recognize him? The clear implication is that you are supposed to know that person. Tell me something about that person that you know. And the concern about that among the defense bar, these are usually federal criminal drug cases, the suggestion is that you have just told the witness to make up something about that person because we have an interest in that person and there's deals to be made here. We will make a deal with you if you will testify against this person. And that's really, really dangerous.
That is, and that's troubling. I don't know that that's the majority of situations. I think often what happens is what happened for Jennifer Thompson and Ronald Cotton. Jennifer Thompson and Ronald Cotton have written a book together called Picking Cotton about their experience where Jennifer wrongly identified Ronald Cotton as the perpetrator, and then DNA proved that he was innocent.
This was a sexual assault case. It
was a sexual assault, and she was convinced that she got the right person. But part of what led to her strong conviction was, she chose Ronald Cotton from the lineup, and afterwards she had affirmative feedback where the officer was like, good, you chose the suspect. And when she chose him from the live lineup, the officer said, good, you chose the same person that you chose from the photo array. And that wasn't ill-intentioned, but that further cemented for her, this is the person who did it.
Too often there comes that moment in a courtroom during a trial when the prosecutor asks the witness, is the person you saw, or is the person who did it to you, or who is the person who was involved, who was even driving the car, present in the courtroom today? And the witness will point, if you're French, says, j'accuse, I accuse you, or that's him, that's her sitting right there. Mm-hmm. And by that point, and usually people in the courtroom go, whew, and the jury will set up straight now. Maybe nod knowingly, but really all that exercise is do you recognize the person that we have told you was the perpetrator of this crime, or whose picture you have seen before? That really isn't a strong moment. In fact, it just has a lot of stage presence and drama associated with it.
Well, and emotionally, it's a powerful moment, I think, both for the witness and for the jury. And again, further emphasizes the importance of getting it right at the very beginning. I mean, the lineup is the very first interaction that this witness has with photos of who the suspect could be, right? And from there, it proceeds. Oh, here's the person. Oh, he was arraigned. Oh, here's this hearing. But if we go back to the very beginning, that's when your memory can start to be altered. And at each stage along the way, you can have further confirmation, because you believe in our criminal justice system, that it's that person.
We're talking about eyewitness testimony. My guest is West Virginia University law professor Valina Beatty. I'm Dan Ringer, and this is The Law Works. When I watch television crime shows, and I don't watch a lot of them, but I do watch some of them, and I see this parade across the stage lineup, oftentimes the suspect is in the lineup and the suspect's lawyer is behind the two-way mirror to protect the suspect's rights. With photo lineups, the suspect's lawyer is not present. Maybe he doesn't even know that photo array is being used. Do you have any problems with that sort of thing?
Well, I think this again goes back to why it's important for law enforcement to be implementing the correct protocols so that we can have the most accurate identification. And I will say for West Virginia, this is a collaborative process right now to focus on eyewitness identification and to actually look to create a model policy that will be used across the state, across all the stations, with the police chiefs, the Troopers Association, the sheriffs, to all be using this new knowledge and science to have the most effective and accurate identifications and protocols.
Police agencies are working with you?
Yes, so there's a bill that's being introduced by Senator Bill Laird. He is the champion of this bill. He's a former sheriff from Fayette County. He was a sheriff there for 16 years. And it's a bill for law enforcement to come together and to create this model protocol and take into consideration the changes in science.
What changes are you proposing?
Well, there was a study that came out just last year by the American Judicature Society that actually ran photo lineups in actual police stations with actual cases in 4 different cities. And the results of that confirmed what I've spoken about earlier on this show about the importance of sequential photo presentation and the blind presentation, that the officer not know the photo.
So there won't be, if this bill passes, there would not be any more number of photos laid out and pick the perpetrator from this group of photos?
Well, if the bill passes, the bill creates, it mandates that the Subcommittee on Law Enforcement Policies, the LEP subcommittee, work with prosecutors, public defenders, with the West Virginia Innocence Project to create a model protocol. And that model protocol would address the sequential presentation as well as the blind administration.
So the bill doesn't say this is the way you do it?
Correct. It's much more of a opportunity for law enforcement to work collaboratively to realize what works best in West Virginia given what we know about science now.
You said police agencies are working with you in developing this bill and the protocols that will come from it. Is the State Judicial Association, the State Bar, the Prosecuting Attorneys Association, are they working with you?
Currently, the Prosecutors Association does know about the bill and is talking with law enforcement about the bill. In terms of the judiciary, they are in the bill as someone to be part of drafting the model protocol. But at this point, they haven't yet been involved with discussions.
State Bar?
State Bar, also a couple of members have spoken about it. Yeah, I mean, it's an issue of concern to attorneys, absolutely, and to prosecutors and defense attorneys for what you point out to be that moment in the courtroom. But really, it's law enforcement who are on the ground and who are doing these lineups and need to, again, make sure that our communities are safe while also making sure to get the right person.
We have a wide range of police agencies in West Virginia, and I think it's true in most states. We have small-town police forces, which may just be Officer Smith, who
Correct.
Walks around the town.
Just a few officers.
1 or 2 or 3 officers. We have relatively large towns or cities, Wheeling, Charleston, Huntington, Morgantown, some others, that have police forces that number dozens of police officers, budgets perhaps of millions of dollars. And then we have what are quasi-private police agencies like the security police present on university campuses, college campuses around the state. But all of them are tasked with doing it right, whether it's 1 or 2 police officers or whether it's 12 dozen police officers. And in my experience, I was a prosecutor for a couple of years, most of them want to know how to do it right. They don't set out with evil intent, we're just going to arrest you because you're good enough. They want to do it right, and they require and hope for and ask for direction.
Right, right, because they're motivated by public safety. Absolutely. I mean, they want to get the right person as well. And part of the reason behind having this model protocol and why law enforcement is on board with it is providing that uniformity, is reaching out to all the corners of the state so that everyone is on board with these new reforms from science and that everyone is able to most accurately get the right person at the beginning.
But without regard to what the legislature may do in this pending session, you are not inactive in getting information about how to do it right. You're involved in some educational efforts now. What are you doing?
Yes, absolutely. Well, we are having a forum at the law school that is more of a academic forum of bringing in speakers to speak to lawyers, to speak to the legal community about eyewitness identification reforms, and then also informational sessions for law enforcement or for prosecutors. Again, bringing in law enforcement from other states where they have implemented these changes. I mean, West Virginia can be a leader in adopting this, but there are other states who already are running with using this information and are using it effectively. So New Jersey, Wisconsin, Ohio, North Carolina, Texas, Connecticut. And so having law enforcement and officers and police chiefs from those states come in and talk about their own experiences with these protocols.
Well, this is not a subject that has just recently been recognized as something that needs to have attention paid to it.
There's over 30 years of studies that have been done. I believe it's coming to a head now because the New Jersey Supreme Court about a year ago came down with a very pivotal decision, New Jersey versus Henderson, where the court said we have to change how we're admitting eyewitness identifications, and we need to have stronger protocols at the very beginning level. We need to have stronger protocols with the law enforcement.
Well, does this come out of your Innocence Project work, or is?
It does, absolutely, yes. One of the cases, I was previously in Mississippi, and one of the cases that is an exoneration case in the past few years in Mississippi, the wrong perpetrator was chosen twice, leading the actual perpetrator to commit multiple crimes. It really is very much a matter of public safety to get the right person.
Well, good luck with your efforts to educate all of us.
Thank you very much.
These issues. And maybe get some of the difficulties cleared up and maybe even eliminated. Professor Valina Beatty, West Virginia University College of Law, thank you very much for being with us.
Thank you.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes.
The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975, which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.